Now, if you want to close down a company business that's a limited company, there are basically 4 ways to do this. Now, the method that you deploy in order to close the company down is going to depend upon ultimately the structure of that business. And what I mean by the structure of that business is whether the business is solvent, able to pay its debts as and when they fall due, or whether it is insolvent and it is essentially completely unable to pay its debts when they fall due. An alternative analysis of solvency is whether the balance sheet of the assets are exceeded by the liabilities, and in that instance the company will be insolvent. And solvency is very important because the way in which you, generally speaking, shut down a solvent company is going to be distinctly different from an insolvent one, because the options legally are different. And many of those options come from the Insolvency Act 1986. There is also a particular option which is actually technically and legally available to both types of company in terms of a solvent versus an insolvent one, in the Companies Act 2006, which I'll come on to, which is the strike-off dissolution procedure. But generally speaking, because of the nature of solvency versus insolvency, it's going to be very different how you essentially look to wrap up a company that is solvent as opposed to one that's insolvent. So if you've got a company that's insolvent, it's got debts, it can't pay them, you want to shut it down because it's ceased trading, what's going to happen is those people are creditors who suffered loss. They've traded with the business and they've suffered a loss. Now, there are consequences for that, and the structure therefore is going to be different compared with a situation where there is no loss to be suffered by anybody. One of the privileges of limited liability inevitably is that there's going to be the company being a separate legal person from its directors and indeed from its subscribers and shareholders, members. The debts of the company are locked and structured through the company. They are not structured through the individuals that necessarily run or own that company. And so what that means is that when people suffer loss, one of the, if you like, privileges for being able to legally be able to wind up an insolvent company under the Insolvency Act is that, generally speaking, if you're going to liquidate it, you're going to be subject to some review, and the person who's going to review is the liquidator, because ultimately a director who runs a company into insolvency, potentially through no fault of their own, and this in itself, having an insolvent company is not misconduct. It's whether getting to insolvency was caused by misconduct or whether it was caused by genuine factors to a large extent beyond the director's control, but certainly not due to blatant negligence, misconduct, and factors completely within the control of the director. So when we're talking about an insolvent company that can't pay its debts when they fall due, potentially the most popular route to shut it down will be the creditor's voluntary liquidation procedure. Now, although it's called creditor's voluntary liquidation, it's actually a procedure that's initiated by the directors of the company. They will start the process, they will convene a board meeting of the directors, look to pass a resolution by a majority of the board, subject to what the constitution, the articles of the company say in terms of how resolutions of the board are passed. But one assumes that for most small, medium enterprise companies that a simple board majority from the directors will suffice. So, if you pass the board resolution, the director can then move on to appoint an insolvency practitioner firm, somebody like myself, to start the liquidation process. And the next stage will be, apart from complying with various regulations, will be to convene a meeting of the members. Now, in most cases, the members of a company are going to be the shareholders, because most companies in the UK certainly are limited by shares. Now, in order to pass a resolution, you're going to need 75% of the members, shareholders, to pass that resolution. Now, the way in which you look to pass that resolution is going to change what that 75% means. So if you're going to do it by way of a meeting, which should be available under the company's articles, then the 75% position is going to be 75% of the people who attend and who are eligible to vote, and in fact do vote at the meeting. So if only a small proportion of the shareholders turn up to the meeting to vote, that doesn't matter. What matters is that 75% of those who are eligible and turn up to vote, that 75% of those that do pass the resolution. Even if 99% of the shareholders do not vote and do not turn up, they've had their opportunity to have a say and they've neglected it for whatever reason, so it doesn't matter. However, that's very, very, very different from if you pass a written resolution. A written resolution will actually require 75% of the shareholders to vote in favour of the written resolution. Otherwise, it cannot be passed. It's as simple as that. Now, that will enable you to get the company through a special resolution, 75% or more, into voluntary liquidation. If the company is insolvent, it will have to, and you're using the voluntary liquidation procedure, you have no choice but to use the creditor's voluntary liquidation procedure. And the creditor's voluntary liquidation procedure means that there is going to be a subsequent approval. Once the shareholders have put the company to liquidation, there effectively, within a short period of time, has to be a subsequent approval by the creditors as to the appointment of the liquidator. Because let's not forget one thing here, that the reason you have to have a liquidation procedure, in most cases, if a company has got unpaid debts and cannot pay those debts and cease trading, etc., is because, in effect, there has to be independent scrutiny of the directors for causing loss to the creditors, and there has to be independent reporting to the Insolvency Service at the Department of Business in relation to the conduct of the directors. Now, what that means is that the appointment of the liquidator has to be ratified by the creditors, because the directors cannot appoint their own liquidator. It's a bit too close for comfort, and therefore it's a bit too much like marking your own homework when you're the one who's subject to scrutiny. So the creditors have to ratify that position. Now, in most cases, the creditors will in fact ratify the appointment of the chosen director. And ultimately, that is how you get the company into creditors' voluntary liquidation. Liquidator will be appointed, realise the assets of the company, and after the costs and expenses of liquidation, if there's money left over, then make a distribution to the creditors in accordance with the statutory order of payment in insolvency proceedings. So that is the first key way to put a company to close an insolvent company down. And it's in fact probably one of the most popular ways for a director to put an insolvent company and to close it into liquidation and to close it down. Now, there's another route, which is to use the court system, which is known as compulsory liquidation. And what the directors will do in that instance is they will issue a winding up petition the court on the basis of the fact that the company is insolvent, that it should be wound up. And if the court is satisfied, which in general terms, if the directors are doing this, they will be, for the most part, the court will then make a winding up order. Now, the effect of that is that a government civil servant who works for the Insolvency Service, which is a government agency in the Department of Business, will be appointed as the liquidator in the first instance, known as the official receiver. And the official receiver will conduct the investigation into the conduct of the directors and consider whether or not that warrants some sort of disqualification action. What can happen is that creditors can nevertheless make a request to the official receiver to convene a meeting of creditors for the purposes of appointing somebody else as a liquidator in place of the official receiver. So that is the two liquidation routes to closing down a limited company business. Now, if the company is solvent, on the other hand, there are essentially two procedures. One is liquidation and the other is the strike-off. Any liquidation procedure comes under the Insolvency Act 1986 rules, and a strike-off procedure is under the Companies Act 2006 rules. Now, if we're talking about therefore, for a solvent limited company business closure, members' voluntary liquidation. And effectively, the key difference between members' voluntary liquidation and creditors' voluntary liquidation is that it's the members that determine the appointment of the liquidator. The process is similar in the sense to creditors' voluntary liquidation, in the sense that the board has to initiate the resolution to wind the company up. You don't have to have a members' or shareholders' resolution and 75% again. A key distinction is that in order to enjoy the privilege of members' voluntary liquidation, which has certain potential tax benefits, such as a distribution by the liquidator being under the capital gains tax provisions rather than, say, income tax type provisions, which can lead to certain tax savings, and particularly if there is the use of business asset disposal relief, then the net effect of all of that is that you have to do what's called a declaration of solvency. And one of the directors will have to declare that the company is insolvent, and it's a statutory declaration. Okay, so it has to be done, it has to be the truth, it has to be accurate, and this will set out the statement of affairs, which is the list of the assets and the liabilities, and demonstrate that the company is solvent. It's quite a serious matter if you sign a declaration of solvency when a company is insolvent. And ultimately, the liquidator is appointed, realises the assets, and then makes a distribution after the costs of liquidation to the shareholders. Now, the final way which we can use to wind up a company, and then obviously we're on solvent companies, is the company strike-off procedure. Now, this is by far potentially the fastest and the cheapest. Not necessarily the most tax efficient. If a company's got more, £25,000 or more of assets, then basically the members' voluntary liquidation procedure may very well be more cost effective due to its tax efficiencies than, for example, if you're using the company's house DSO1 form to strike off the company under the Companies Act 2006. So it's not always, but generally speaking, aside from that, it will be effectively the cheapest way and potentially the quickest way to close down a solvent limited company. And you simply fill in a DSO1 form at Companies House. It's a pretty quick and swift form to fill in. The only thing is there are various restrictions. You cannot use it in certain instances as provided for under the Companies Act. In particular, the company can't have been trading within the last 3 months, can't have changed its name within the last 3 months. Very important is that within 7 days of filing a DSO1 form at Companies House, you've got to send it to all the members, the directors, the creditors, and so on. But if you comply with the rules, it can be a very cost-effective. I mean, it's cheap. Online, it's something like £33, I think it is, in order to file an online DSO1 form. Now, that procedure is potentially, as I say, the swiftest, potentially, and the cheapest to essentially close down an insolvent company. A solvent company. Now, the question of an insolvent company is it can potentially and legally be used to close down an insolvent company. But what tends to happen is that creditors will object to that procedure being used, and that can then block it, particularly if the objection is renewed and is persisted with by the creditors. So it tends to be unsuitable as a mechanism for closing down an insolvent company with debts that ceased trading. And that is the 4 ways that you can close down a limited company business. Questions, queries, concerns, give us a shout. We know insolvency inside out.